Hello friends. Today we are going to discuss about laws for senior citizens. Basically, I'll be discussing about the legal framework for protection of senior citizens in India. I'm Dr. Suresh Badadmat, Professor of Psychiatry, working at NIMANS, Bangalore. Before I start my presentation, I'd like to place this disclaimer. This presentation is for academic and training purpose only. This presentation is not a substitute for professional legal opinion. For legal opinion, please do contact an advocate. Conflict of interest? None. In this video, I'm going to discuss about the legal framework for protection of senior citizens in India, the Maintenance and Welfare of Parents and Senior Citizens Act of 2007, and also the case laws decided by Supreme Court of India. Let's look at the international efforts to protect the senior citizens. Of course, United Nations Declaration of Human Rights, Covenant on Civil and Political Rights, and also International Covenant on Economic, Social, and Cultural Rights discusses about that all human beings are equal and discusses about against discrimination. And invariably, senior citizens fall into this category. However, the efforts to focus on senior citizens came only in 1982. That United Nations Vienna International Plan for Action on Aging came into picture. Within another 9 years, United Principles for Older Persons were also drafted. And later, the Madrid International Plan for Action on Aging 2002 came into picture. With all this momentum, there is now strengthening the older people's right towards a UN convention is in discussion. There are NGOs who are working to move towards a formation of United Convention for Senior Citizens Protection of Rights. Of course, we have seen UNCRPD, that is United Convention on Right to Persons with Disability. In similar lines, there is a move to form United Nations Convention on Senior Citizens' Rights. Of course, that is the need of the time. Basically, during the COVID times, the senior citizens were at high vulnerable and also high risk for mortality. In this regard, we have seen huge amount of human rights violation against senior citizens and also access to health and also access to resources. Now, the time has come to formulate United Convention on protection of senior citizens' rights. Now let's look into the Constitution of India. Although there are general provisions for every citizens of India and also to the human beings, are there any specific articles focusing on senior citizens? As far as my knowledge goes, there are two important articles, Article 41 and Article 46 of the Constitution of India. What does Article 41 speaks about? It speaks about right to work, right to education, and to public assistance in certain cases. This Article 41 clearly states that state shall, within the limits of its economic capacity and development, make effective provisions for securing the right to work, right to education, and public assistance in case of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. So in this situation, there is a specific mention of old age. Now let's look into the Article 46. The Article 46 of the Constitution of India clearly says promotion of educational and economic interest of scheduled caste, scheduled tribe, and other weaker section. So in this weaker section, the senior citizens have been included. Let's look into that. What does it say? The state shall promote the special care, the educational and economic interest of weaker section of the people and shall protect them from social injustice and all form of exploitations. Of course, this article is very specific, which clearly says shall protect them from social injustice and all forms of exploitation. As you know, senior citizens are exploited more at home rather than in the society. Hence, we need to have certain provisions which can protect the senior citizens within the family context. Of course, these Article 41 and 46 are directive principles of state under the Indian Constitution, and they are under the Chapter 4. Although the directive principles, as stated in Article 37, are not enforceable in any court of law. But however, it encasts or it casts obligations on the state to do something and what to do. So these are state policies. Hence, there is some amount of obligations by the state towards the senior citizens, but of course, they are not enforceable in the court of law. Let's look into certain personal laws. The personal laws are specific to certain religion. For example, the Hindu Adoption and Maintenance Act of 1956, Section 20, talks about the provision for maintenance of parents under Hindu personal law clearly indicates that children, that is, who are major, both daughter and son, are obligated to provide maintenance to their parents, whose parents are unable to maintain themselves by any means. That means if the parents do not have any type of income or support, that means the children who are major, that is both the son and the daughter, are obligated to provide maintenance to their parents. Similarly, in Muslim law, the children who are major, both son and daughter, are obligated and they have a duty to maintain their aged parents. But however, the Christians and Parsis laws do not talk about the maintenance for the parents. However, parents who wish to seek maintenance have to apply under the provision of Criminal Procedure Code. These are all personal laws, but CrPC is a secular law. What does Criminal Procedure Code for Protection of Senior Citizens speak about? Under Section 125 of CrPC, it clearly says that order for maintenance of wives, children, and parents. So here, the parents have been very clearly said. Section 125, subsection 1D clearly says order for maintenance of parents states that a father or mother unable to maintain himself or herself, that is both father and mother, they are unable to maintain himself, a magistrate of first class may, upon the proof of such neglect or refusal have been seen or been produced, the first class magistrate will order such person to make a monthly allowance for maintenance of his wife, of child, father or mother at such monthly rate not exceeding 500 rupees in the whole. So this is 500 rupees is very less. But however, there is an indication by the drafter of Criminal Procedure Code to provide maintenance to the parents. But however, CrPC, being a criminal procedure code, will go to the court. Whoever wants to, like senior citizens or the parents wants to ask for maintenance for the amount of 500 rupees, they need to the court. And of course, as you know, the criminal system, especially in India, has adversarial procedure where the senior citizen have to ask for legal aid or else have to pay for the lawyer to fight his case, and it will take its own sweet time. And hence, it is very adversarial. In this similar regard, national policies for senior citizens was taken up by Government of India. The first important move, that is national effort to protect senior citizens, came in 1999. The Government of India introduced a national policy on older person was introduced. Later, as you know, the Code for Criminal Procedure Code 1973, the Section 125, also under secular law, gives protection. But as I mentioned, it is adversarial in nature. Further, in 2010 and 11, Ministry of Health and Family Welfare brought in healthcare for elderly. It launched a national program for healthcare of elderly to promote the medical care of senior citizens. Because senior citizens need to go to the hospitals for their disability, for their distress, for their any physical ill health, they need to visit the hospital. And hence, there was a need for a policy which gives priority for senior citizens. But of course, all these did not matter much. Hence, there was a need for comprehensive laws to protect the senior citizens in India. And considering the ineffective laws which were prevailing either in the personal laws or else in Criminal Procedure Code or else in the Constitution of India, these laws were not consistent across all senior citizens, which was religion specific, and of course, CrPC being very adversarial, and senior citizens have to go and fight in the court of law with their own children. And hence, in this family context, there was a need to come up with a law. That is this, the Maintenance and Welfare of Parents and Senior Citizens Act 2007. Let me repeat this. The Maintenance and Welfare of Parents and Senior Citizens. This is not just a Senior Citizens Act. It is also for the protection of parents. Let's go into this legislation. This act has 7 chapters and 32 sections. Let's look into the preamble. The preamble is basically what is the reason, what is the main agenda, why this legislation has been implemented. This legislation clearly says to provide effective provisions for the maintenance and welfare of parents and senior citizens guaranteed and recognized under the Constitution of India. That means the senior citizens needs special legislation to protect them. Although the Constitution of India provides this, but they need a special legislation. That's the reason this Maintenance and Welfare of Parents and Senior Citizens Act 2007 came into picture. Let's look at the way this legislation has been drafted. As I mentioned, there are 7 chapters. Each chapters have been placed in a beautiful way and in an appropriate way. The first chapter, which has section 1 to 3, talks about the title, definition, and also talks about overriding effect from other legislation. Moving to the chapter 2, which talks about maintenance of parents and senior citizens, how the procedure is done, how the case is given, who is going to decide, how the tribunal is there, how the tribunal is going to argue the case, decide the case, and how it's going to enforce the decision, and what are the appellant, appeal, and appellant tribunal are discussed here. Moving to the chapter 3. The chapter 3 has only one section, that is section 19, which casts obligation on the state for the establishment of old age homes. Suppose if the children are not there, or if the children are migrated, or they themselves are poor, now the state has an obligation to provide protection and establishment of old age homes under section 19. Moving to chapter 4, which discusses about section 20, that is provision for medical care for senior citizens. And this is the heart and soul of this legislation from health perspective. Moving to chapter 5, which is from section 21 to 23. Here it discusses the protection of life and property of senior citizens. As you know, the properties of senior citizens are either taken by the family members, that is their children, or relatives, or maybe neighbors, and they are discriminated and they are not given any protection. Hence, section 21 and 23 discusses about this. And finally, section 24 to 25 discusses about offenses and penalties and procedure of trial. And finally, the chapter 7 is miscellaneous in nature. Let's discuss each one of these chapters and section. Moving to chapter 1. As I mentioned, chapter 1 to 3, chapter 1 has section 1 to 3. That basically title, application and commencement, and the definitions. We need to spend some time in discussing about the definitions under this legislation. What does children mean? Children means son, daughter, grandson, or granddaughter. That means who are not minor, they are all called as children. And they have been casted an obligation to protect and to provide maintenance to the parents who are unable to maintain themselves, or else if they do not have any financial assistance. As I mentioned, children are son, daughter, grandson, and granddaughter. That means there is no discrimination between daughter and son here. Moving to the parent. What does it mean here, parent? Parent means father or mother, whether they are biological, adoptive, or stepfather or stepmother, as the case may be, whether or not the father or mother is a senior citizen. That means, as I mentioned earlier, this legislation is not only for senior citizens, but also the parents. Here, the parents need not be senior citizens. Even if they are below 60 years, they can ask help under this legislation. So, we have to be very clear, not only biological, stepfather, stepmother, adoptive, all those come under this purview of this legislation. Moving to the relative. Any legal heir of the childless senior citizens who is not a minor and is in possession or would inherit his property after his death. This is very important here. There are many childless senior citizens or parents, and if they have been discriminated or if their property is going to be had by somebody else, and the legal heir has to provide protection and maintenance. So that is, those are these relatives have been brought in under the obligation of this legislation. Moving to the senior citizen, any person who is aged above 60 years are considered as senior citizens. Let's discuss about what does it mean as maintenance, property, and welfare. Because this maintenance is one of the important word which has been in the title of this legislation. Maintenance includes provision for food, clothing, residence, and medical attendance and treatment. So it talks about the important components: food, clothes, residence, and health. Moving to the property. The property means any kind, whether movable or immovable, ancestral or self-acquired, tangible or intangible, includes rights or interests. So that means property as per the definition under this legislation. What does welfare means? Welfare means provision for food, healthcare, recreational centers, and other amenities necessary for senior citizens. So you need to remember this whenever I am discussing about maintenance and welfare. Moving to chapter 2. This chapter 2 has section 4 to 18. You can see all these been mentioned from 4 to 18, which talks about the procedure. The procedure, how the parents and senior citizens, what are their rights, and against whom they can go, where they can lodge the complaint, and how these tribunals will take the complaint, and how they will proceed, within how many days they will give the decision, and who can appeal, who is the appellate authority, and how the decision given will be enforced. And finally, if they don't listen to this order or somebody violates this order, especially the children, what are the punishment? And also the maintenance officer have been discussed in this chapter 2. Let's move to discuss each one of them. Here section 4 talks about maintenance of parents and senior citizens. Here senior citizens, as I mentioned, any person above the age of 60, and parents either biological or adoptive. Against whom the maintenance can be asked? Against children both son and daughter. Relative means if a childless parent is there, the relative who is going to be inherit the property of these parents will be considered as relative. So those are the people whom are responsible to provide maintenance. Now, who the application for maintenance? Who can ask for application? Any senior citizens or parents. Whether if the senior citizens or parents are not in a position to ask for application, NGO or suo motu by the tribunal can be considered. Suppose if there is an application is given, should the senior citizens or parents wait for longer duration? No. The tribunal can give interim maintenance order. That means when the case is going on, the interim order for the children to give maintenance can be given. And the cases need to be disposed within 90 days, maximum another 30 days. That means within 120 days, the case needs to be disposed. Once the application has been given, that application will be forwarded to the persons, that is children. It may be one or more. And children can implead, or else they can, yes, we will give maintenance. If there is unpaid maintenance is there, the tribunal has the power to give fine or even imprisonment for 1 month under this section 5. Moving to the section 6, the jurisdiction and procedure. Where does this tribunal sits? Either where the senior citizens or parents are staying, or where the child or the children who is major is residing. And once the application comes to the tribunal, That application will be processed and will be forwarded to the children. It may be one or many. And once the proceeding will start, the proceeding will consider the presence of both the parents or the senior citizens and children. That means principles of natural justice will be considered. If any of the children or all the children refuses to come, then the ex parte decision will be taken by the tribunal. Further, there will be conciliation efforts will be made so that the senior citizen stays within the family and the children will look after them. And here, when the conciliation or reconciliation process takes place, the counselor need to decide and submit a report within 1 month. The director in the Ministry of Social Justice and Empowerment at New Delhi will serve the summons for the children outside the country. Imagine if the parents are staying in India and the children are abroad. If they give a complaint to the tribunal, who will serve the summons? Because children are in abroad. In such a scenario, the director in the Ministry of Social Justice and Empowerment, New Delhi, will serve the summons to the children through the respective embassy. That means this legislation is applicable not only in India for the citizens of India who are staying abroad. That means there is a clear intent by the drafter of this legislation to provide protection and maintenance to the senior citizens and parents. What is the constitution of this tribunal? Here, this tribunal will be presided by a subdivisional officer of the state. That means one subdivisional officer will be there who will be presiding the tribunal, and more than one tribunal can be formed in a district. That means if there is more cases are there, and of course more tribunals will be done. If the tribunal requires an expert, they can be added during the proceedings. And the proceedings will be summary procedure. That means it will not be adversarial similar to civil or criminal cases. It will be summary procedure. And with regard to summoning or requiring the evidence, the civil court procedure will be given to this tribunal. And if the order of maintenance is given, that will be not more than 10,000 rupees per month. Unfortunately, although this legislation came in 2007, 10,000 rupees is very less. Hence, there is a discussion of amendment. If there is an alteration in allowance of maintenance has to be done, that can be done by the tribunal, depending upon the circumstances of the children or the senior citizens. If there is any change, the allowance can be changed. Suppose if there is an enforcement of the order of maintenance has to be done, that during the enforcement, the tribunal has been given the power of the criminal court as per chapter 9 of the Code of Criminal Procedure Code. Similarly, when the enforcement has to be done, the same power of the criminal court has been given. Further, if the court has ordered to give maintenance, it has to be deposited within 30 days. And if they do not give the maintenance, the tribunal has the power to ask for interest of that money. And the interest will not be less than 5% and not more than 18%. That means senior citizens, if their maintenance is not paid, the interest will be decided by the tribunal. Further, this legislation also talks about formation of appellate tribunal. That means each district will have an appellate tribunal which will be headed by the district magistrate. And of course, please remember, the appeal will be with the senior citizens and parents. Children do not have appeal authority here. And appeals should be within 60 days and only by the senior citizens and parents. And here, when the appeal is done, the decision to be taken in 1 month. Further, one of the important aspects of this legislation is right to legal representation by lawyer has been prohibited. Simple reason, the lawyer, if he is there, that means there is a need for hiring a lawyer. Imagine, how will senior citizen going to hire the lawyer? And even if there is a legal aid is given, since the lawyer is there, there will be adversarial situation, and then the cases will be prolonged. Hence, the drafter of this legislation is very clear. No lawyer will be allowed to represent in this case. But however, there has been amendment for Advocates Act. In that, any tribunal in front of them, they can represent. So there is a conflict regarding this. However, the case laws or the amendment of this legislation is weighted, and we have to see whether this will continue or else the need for advocate will be asked here. However, the current system of not having a legal representation will help the senior citizens. Further, Section 18 talks about maintenance officer, that is district social welfare officer, who is going to help the senior citizens with regard to protection of their rights, drafting the case, and also fighting in front of the tribunal. Moving to the Chapter 3. Here, Chapter 3 casts obligation on the state for establishment of old age homes. Every district should have one old age home which will cater for 150 senior citizens. That means every district should provide this. At the same time, a scheme for management of this old age home also to be done. Further, standards and various types of services to be provided for medical care and entertainment to the inhabitants has to be done here. That means it's not just a residential place. It will provide medical care, minimum standards, food, all those things need to be established by the state government. Moving to the Chapter 4. As I mentioned earlier, Section 20 of the Chapter 4 talks about medical support for senior citizens. That means this legislation mandates providing beds for all senior citizens in every health establishment. There should be a separate queue for senior citizens and parents. That means in all public and private establishment, there should be a separate queue for senior citizens. Further, facility for treatment of chronic diseases, research, and also earmarked facilities for geriatric patient in every district hospital should be there. Such a wonderful thinking by the drafter. Moving to the Chapter 5. Chapter 5 talks about the Section 21 to 23, that is, measure for publicity awareness of welfare of senior citizens, and Section 22 talks about authorities who may be specified for implementing the provision of this act, and also Section 23, the transfer of property to be avoided in certain circumstances. Section 23 has been under litigation, and also it is one of the important decisions which has been taken by Apex Court. I'll be discussing that. Looking at the Section 21. Section 21 talks about wide publicity about the legislation, social welfare measures to the public, to the judicial officers and police officers should be done. At the same time, coordination between various ministries has to be done. Imagine, senior citizens requires help from social welfare, from police, from health department, from pension, if they want to undergo training. So they require support from almost all departments. Hence, there is a coordination required. Section 22 talks about authorities who may be specified for implementing the provision of this act. This act talks about district magistrate, and the district magistrate will be supervised and he will authorize subordinates to implement this act. Moving to Section 23. As per the rights of the senior citizen, Section 23 plays a very crucial role. Here, the transfer of property to be void in certain circumstances. Any senior citizen who has transferred his property to his children by gift or otherwise, subject to the condition that transferee, that means the person who receives the property, will provide the basic amenities and basic physical needs of the senior citizen. And such children or transferee refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed or declared void by the tribunal. Such a beautiful discussion. Further, The right to receive maintenance may be enforced against the transferee or the children if the transferee has notice of the right or if the transfer is gratuitous. That means here he has refused to provide the maintenance. And any senior citizen is incapable of enforcing his rights, any NGO can go to the tribunal. Let me give an example. If the father has given the property to his children, once the property has been transferred, all of the children have refused to take care of the senior citizens, that is, parents. In such a scenario, what will happen? The property has already been given, and nobody wants to look after their parents. Now, under Section 23, if they go to the tribunal will decide that the transfer or the property deal or the agreement will be considered as null and void. That means the property will come back to the parents because the children failed to provide maintenance to the parents. Moving to chapter 6. Here, if there is an exposure and abandonment of senior citizens, imagine if the senior citizens and parents have been exposed to the harsh environment, not being given residence, and they have been abandoned. In such a scenario, the children can be punished up to 3 months of imprisonment or 5,000 rupees fine or both. In such a scenario, the cognizance of offense means every offense under this legislation are cognizable and bailable, and it has to be tried summarily by magistrate. That means the case need to be heard on day-to-day basis so that the protection of the senior citizens' rights will be upheld. Moving to the chapter 7. Here, it talks about the section 26, officer to the public servants, jurisdiction of civil courts, protection of the people who have taken in action in good faith, power to remove difficulties, power of central government and review, and also power of the state government have been discussed in chapter 7, that is section 32. So, till now we discussed about the legislation. And again, the rules of this legislation is also very important to know. Rule 20, it talks about role of the police. Here, in this rule, it has been mandated that each police station to maintain the list of senior citizens living in the jurisdiction with specific emphasis on those living alone. That means, if there is a police station in a locality, now this rule casts obligation on the SHO or the inspector of this police station to make the list of all senior citizens under the jurisdiction of this police station. And he need to visit or give emphasis on the senior citizens who are living alone. That means they need to protect them. They need to protect and also promote the rights of the senior citizen. And Rule 20 has been implemented in certain police station, and some of the police station has not done it. Now the time is ripe. Every police station need to list all the senior citizens in their jurisdiction. Moving to the role of National Legal Service Authority. As you know, National Legal Service Authority Act of 1987 was implemented. Under that, there is a scheme called as Legal Services to Senior Citizen under 2016 scheme has been floated. Here, this scheme is targeted to promote access to legal and welfare measures of senior citizens. The legal service authorities at various levels have promoted awareness about this legislation and government welfare schemes to senior citizens. Where do we find these legal service authorities? Legal service authorities are there at the district court, taluka or tehsil court also, and at the state level, state legal service authority, at the high court legal service authority. That means if you are in a district place, you need to go to the district court complex and ask for district legal service authority. If you are in the high court or near the high court, go to the high court and ask for high court legal service authorities. If you are in a taluk or tehsil, you can go to the taluka court and ask for taluk legal service authorities. These authorities have been casted with an obligation to promote access for legal services by the senior citizen and also welfare measures. And they need to protect, promote the rights of the senior citizen. Let's now discuss some of the important Apex Court decision with regard to Senior Citizens Act. First and the foremost, Dr. Ashwini Kumar versus Union of India 2018. The former Law Minister Dr. Ashwini Kumar, seeking the enforcement of rights of the elderly under the Article 21, specifically appealed under the PIL to the Supreme Court in the areas of pension, shelter, medical and geriatric care, as well as the implementation of this legislation, senior citizens legislation. So this PIL was taken and the Supreme Court gave an important verdict. With regard to that, the Apex Court gave a direction to the Union of India to file a status report regarding the number of old age homes in the country and in each district how many are there. The medical facilities and geriatric facilities that are available for senior citizens in each district, the status report need to be filed by both each state and also by the national central government. Further, a plan of action should be prepared by the Union of India with regard to senior citizen. Implementation of the Maintenance and Welfare of Parents and Senior Citizens Act of 2007 that has been casted. And also revisit the grant of pension to the elderly so that it is more realistic rather than a promise given during the election. So these important decisions have been given by the Supreme Court. In spite of the passing of this legislation, Maintenance and Welfare of Parents and Senior Citizens Act of 2007, it remained on the books, that is in paper. Hence, the Supreme Court took it very seriously and asked central government and state government to file a status report and also to implement this legislation. There was another important landmark judgment which came in 2020. This case law is Srimati S. Vanitha versus Deputy Commissioner of Karnataka. This case is from Bangalore. Miss Vanitha got married in 2002. Her husband owned certain property. Within few months of marriage, there was a marital discord. Immediately, the husband transferred the property to his father, and father transferred the property to his wife. Because of marital discord, Vanitha gave a complaint to police under domestic violence and dowry harassment case against the mother-in-law and the husband. Considering there was a case, immediately the father-in-law and the mother-in-law filed a case harassment against by the daughter-in-law in the tribunal. And the tribunal gave the verdict in favor of the senior citizens, that is in father-in-law and mother-in-law, and ordered the deputy commissioner to evict the daughter-in-law from the property. Now, the lady went to the High Court and the High Court also upheld the Senior Citizen Act. Now, under Article 136 of the Indian Constitution, the wife petitioned the Supreme Court challenging the Commissioner's jurisdiction to compel the eviction under the Senior Citizen Act. That means now the wife has the Protection of Women from Domestic Violence Act of 2005 versus the father-in-law, mother-in-law who are trying to fight for their rights under Senior Citizens Act of 2007. That means the two legislations are there, two parties, both one party is under Domestic Violence Act and the father-in-law or mother-in-law are there under Senior Citizens Act. Now the Supreme Court has to decide. According to the section 17 of the Protection of Women from Domestic Violence Act of 2005, it clearly says every woman in a domestic relationship has a right to live in the shared household, regardless whether she has any right or a title or a beneficial interest in it. That means in a shared household, the lady has all the rights. That is under section 17 of the Domestic Violence Act. At the same time, under section 4, 5, 9, 13 and 23 of the Senior Citizens Act of 2007, the tribunal has the jurisdiction to impose an eviction of children and relatives if it is necessary and reasonable to guarantee the senior citizens or the parents' maintenance and protection. That means the lady Under the Domestic Violence Act, she had her rights. At the same time, senior citizens under 2007 Act had their rights. That means there is a clash between two legislation. What did the apex court decide? In this decision, the landmark judgment, the Supreme Court clearly said, eviction proceedings under the Senior Citizen Act of 2007 cannot override the rights of residents of women in a shared household as per the Protection of Women Against the Domestic Violence Act of 2005. That means the wife cannot be evicted under the Senior Citizens Act. Such a beautiful decision. And the Supreme Court also said that the tribunal needs to take decision based on the case-by-case basis. Whether the senior citizens were harassed, abused, whether their property were taken forcibly. Under such circumstances, the tribunal needs to take decision based upon case by case. Just there is a law, you should not close your eyes and implement that. Such a beautiful decision taken by the apex court. Let me remind you, Senior Citizen Act of 2007 cannot override the rights of residents of a woman in a shared household under the Protection of Women from Domestic Violence Act of 2005. Now, there have been certain amendments have been proposed. Amendments have been proposed for the Maintenance and Welfare of Parents and Senior Citizen Act of 2007. Although this legislation is old, not implemented, but there is a need for amendment. The amendment included expanding the scope of maintenance and welfare to a comprehensive measure of physical, mental well-being of parents and senior citizens, not just food, clothes, and residence. There should be a well-being of parents, senior citizen with regard to physical health and mental health. Further, the proposed amendment not only talks about children, it also includes daughter-in-law and son-in-law under the definition of children. Further, removal of this maximum ceiling of 10,000 per month as a maintenance needs to be removed. Depends upon the earning capacity of the children and the lifestyle of the children. At the same time, the maintenance of the parents should be proportional to the earnings. Further, improvement in the disposal of application. If the senior citizens of more than 80 years is there, the requirement is less than 2 weeks, the case needs to be disposed. Further, there is a amendment for online application to the tribunal has also been discussed. Further, the regulation of the senior citizens or old age homes need to be done by the state. Further, there is a requirement under the amendment for the provision of appeal of children. Earlier, if the tribunal goes against the children, they did not have any appeal to the appellate authorities, that is appellate tribunal. Now, the amendment is requesting for that. Further, creation of a national helpline for senior citizens. Although the senior citizens helpline is already been working in certain state effectively. To conclude, my dear friend, this act mandates the statutory provision to support the maintenance and welfare of parents and senior citizens. And this legislation needs public awareness. Further, access to justice should be priority for senior citizens and parents. Fast disposal of case should be the priority in this situation. Further, there is a scope for further amendments. Those amendments are very well required. But however, whether there should be a representative from lawyer should be discussed in detail. And the summary proceeding should be maintained. Adversarial procedure, delay in the case proceedings and judgment should be condoned, and the time should be reduced under the amendments. So, the need of the hour is implementation of the legislation, awareness of the legislation, and also maintenance and social welfare measures enabling should be the priority under this legislation to protect, promote, provide maintenance and welfare of parents and senior citizens across India. Thank you very much for giving your valuable time. Stay safe.